So they sent you up here and you don't have a client?
No, Judge.
Oh, yeah, call you lucky. Okay. Bench warrant will issue for defendant's fit. Where are you from?
I'm from like 45 minutes south of here originally, Your Honor.
Where's that? Where's that? Does it have a name?
Oh, yeah, it's Lambertville, Your Honor. Lambertville, Michigan.
Yes, I know where it is.
But I went to law school in Georgia.
House case, People versus Anna Gunderson.
Good morning, Your Honor. Zach Vignew on behalf of Ms. Gunderson, who I do not believe is present, requesting permission to practice pursuant to MCR 8120 under Assistant Public Defender Asli Bashir.
Under who?
Under Assistant Public Defender Asli Bashir, Your Honor.
So is that the courtroom? I'll wait.
You're under 120. Okay. Apologies, Your Honor. Requesting
for what?
For saying 120 instead of 120, Your Honor.
Oh,
I apologize.
I didn't know if there was just we were renaming them. It's not your fault. It's Miss Bashir's fault. Absolutely, she knows better.
Thank you, Your Honor.
But she listened to Miss Cannon. See, look, and that's what happened. So I know everything that happened. So they sent you up here and you don't have a client?
No, Judge.
Oh, yeah, call you lucky. Okay, permission to practice is granted. Go ahead.
Thank you, Your Honor. I have not been able to get in touch with Ms. Gunderson. We would request an adjournment.
You would ask for a bench warrant.
You said him up here without a client, for sure? You couldn't have found a case where he had a client? It's okay. Never mind. Never mind. I'll send a letter. Bench warrant will issue for defendant's fit. Where are you from?
I'm from like 45 minutes south of here originally, Your Honor.
Where's that? Where's that? Does it have a name?
Oh, yeah, it's Lambertville, Your Honor. Lambertville, Michigan.
Yes, I know where it is.
But I went to law school in Georgia.
Oh. Where?
Georgia State.
Yeah.
Yeah, down in Atlanta.
Seriously? He thinks I haven't been anywhere. Don't do anything. Oh, the football team was awful. Right? Yeah. Well, they had their moments.
They were okay.
Yeah, whatever.
He's a Maryland fan.
Is he?
Yeah.
Or are you just telling me that? You're just telling me that so I don't get on it, right? Aren't you? You just stuck your nose in to try to help the guy out.
He's a Maryland fan, right?
Your Honor, I have a duty of candor to the court. I'm not a Maryland fan.
See, they throw me under the bus.
I have nothing against Maryland.
Mr. Allen. What? He just set you up. Bench warrant will issue bond $10,000 cash surety. That warrant will issue immediately.
Understood, Your Honor.
Welcome aboard, young man. Court calls the case, People versus Trita Guyton.
After the chair on behalf of Trita Guyton. Yes. Oh, and I believe there may be a substitution in this matter. I haven't received.
Substitution from who?
From Mr.
David Burgess.
David Burgess. Yeah.
He says supposed to be on Zoom.
I do have a green sheet.
I don't have that, and the problem is we've got a violation at this point.
I understand. I would request if the court would allow for an adjournment of the violation hearing, just because I have spoken with Mr. Burgess's office. They've confirmed that they do plan to appear on behalf of Ms. Guyton.
That what?
I was under the impression that the court might have received something, but
I have nothing from Mr. Burgess's office. I don't. Is he coming in as retained counsel or is he coming in
retained counsel? Yeah.
As retained? I have nothing then. And I also have an individual standing before me that is not reported to community corrections or testing.
So, Your Honor, I would request Ms. Guyton. I think she was not aware that she needed to test. She was happy to test today.
Where was she at?
I've been going to therapy at Coherent Oaks.
You went straight to therapy?
Yes, I'm in therapy now.
Okay, yes.
And here on Oaks on St. Joe's.
Your Honor, and we can, if we continue to represent Ms. Guyton on this matter, then we can provide verification of that.
Verification of what? She's not complied with the court's orders.
Once when they had to do, communication, they told me I was going to Huron Oaks and that I was dropping you in there and they was going to, that's how I'm supposed to be going. So that's the last I know. Because I've been going to therapy there and I've been dropping me there. I didn't know nothing monkey in the correction.
I'll put it out 1 week for you guys to get your paperwork in order, but as to her bond's revoked. She's remanded. You can get to Mr. Burgess and see what we can do, but all I have is she hasn't shown up for community corrections. I don't know anything about any other program that she says she's in, and she says she's got another attorney, but he's not here.
I see.
Defendant's bond is revoked, defendant's remanded. I'll set this for the 23rd at 9. Court does call the case of the People versus Michael Siegel.
Alexander, on behalf of the people, Your Honor.
James Fifelski on behalf of Mr. Siegel in all 3 files that are up on the docket today. Can you state your name, please?
Michael Anthony Siegel.
All right, we're set for PCC and your motion.
That is correct. I think what we would like to do is adjourn the 2 stalking files, 1336, 1298, because there's other collateral cases that we're both tracking that may have an impact on a possible resolution. And if the court is able to go out maybe about a month or so for that, I think that'd be helpful on both sides.
And I have no objection.
That's on the 2 stalking cases.
That's correct, Judge.
All right. And you want a month out?
Yes, please.
The probable cause conference in those cases will be adjourned to November 20th, 2025. 9 a.m. Bond will continue.
Thank you, Judge. I think the motion is on one of those case files,
Yes.
but if we can address the other, the OWI at this point, we just want to set that for exam. That's the 1515.
On that case,
Yes, Your Honor, to my knowledge.
people have their witnesses available the 28th.
We'll do our best, Your Honor.
That preliminary examination in that matter in person be October 28th, 2025, 9 a.m. That is before
Judge Washington.
Judge Washington.
In Your Honor, on that file in particular, is there a cash bond or was that revoked? Was the PR revoked on that?
That I do not know. I see it. Do you see anything?
'Cause I know bond was revoked on the first stalking case, but I don't know if it was modified on the OWI case.
I don't think that it was.
So on 1298, I show 100,000 cash or surety.
That's the new stalking charge. What do you have on 1515? That's the OWI.
Pardon?
On 1515 OWI, I show a TR bond.
Would the court modify it with low cash bond, please?
Set his bond at $1,000, 10%.
Thank you, Judge.
All right. And that one's all taken care of. That's to your motion.
Super. As to the motion, Your Honor, it's pretty simple. At the arraignment on the newest charge, 1298, there was a request by the people for no phone privileges for my client. As you recall, he had previously been charged with a stalking file. This is in relation to his wife. They're going through a divorce. Working through that, there was a bond violation. We have not disputed that. But at the same time, once the court sent me notice that he was to turn himself in, I told him. He immediately went to the jail. They said there's nothing there, so he couldn't do it that day. Came back the next day, turned himself in. No problems with jail rules, no problem with phone violations at the jail. And so it seems like setting a bond condition on the newest stalking file that prohibits him from calling anybody and everybody when there was never a jail phone violation, I think was either premature or
Or a condition of bond that seemed appropriate given the circumstance.
well, if it's a condition of bond, but he's not bonded out, he's in custody. And, he's in a situation where clearly the people would presumably be monitoring his phone calls. So if he were to make any bad decisions about calling his wife, that would be a problem. So I recognize that he violated bond in the first case, but I would just ask the court to lift the phone privilege restriction in large part because he has multiple pending legal cases. He has tried to reach out to his counsel, both myself and I think it's Miss Musser, Sandra Musser, on the divorce case. But the jail protocol is such that it essentially is
I think
impossible.
You can resolve that with the jail.
Well, my client has tried to. I
think you can resolve that with the jail.
Well, the other component, he has a power of attorney who's handling his other affairs, and that includes trying to assist in things that need to happen with the divorce. That person he would like to contact as well. I just would ask the court, unless there is actually some kind of phone violation at the jail, that the court withhold imposing that condition unless and until that actually happens. He clearly would have a no contact order with both of the complaining witnesses in both the stalking files, and he understands that. He's sitting in jail. He's doing what he has to do. He's not going to be seeking a bond modification in front of this court other than this.
Response.
Your Honor, I would rely a lot on a response. I think MCR 6.165 states is the best that the court may use custody order place conditions on the defendant, including but not limited to restricting or prohibiting defendant's contact with any other named person or persons if they determine those conditions are reasonably necessary to maintain the integrity of the judicial proceedings or are reasonably necessary for protection of those people. I think this case is a great example of that, given that he was out on bond and he contacted both protected parties of the previous bond conditions, as well as someone who was protected by the PPO that originally caused the stalking in the first place. I have my concerns given that in that bond violation, he's calling her, telling her about, he calls the son. There's an hour-long recorded conversation with the son where he does sound intoxicated, which is another bond violation. I have concerns that I don't want him reaching out to them at all and continuing this competitive stalking and harassing his ex-wife or soon-to-be ex-wife and his son. He has previous history of stalking behavior and maybe with this same age. So I have great concerns about the integrity of this case if he has any ability to contact anybody about anything besides his attorneys through the proper methods in the jail that are already in place. So I would ask that his bond remain set and his phone privileges be revoked. I think he's shown clear disobeying of the court orders and inability to control himself when it comes to contacting these parties, and have great fears that if he is given phone privileges, he'll reach out and contact them again.
Your Honor, I just think it's unnecessarily overbroad, given the fact that he is now in custody. When he was out, different context, different circumstances, but he's in custody. He's even been doing the Dawn Farm Jail program. He's going to AA meetings. He's in the right place for where he needs to be right now and has shown total respect for the jail policies and rules.
Motion for bond modification is denied. The counsel made during the course of the argument that somehow the Washington County Sheriff's Office would be interfering with his communications with the attorneys. I want to make it very clear that that has never been anything that I've seen from the Washington County Sheriff's Office in the operation of that jail where that there is any interference in that. Counsel, it becomes in these types of circumstances incumbent upon counsel, if you're not the public defender's office, because there's a dedicated line, to inform the jail that you need to have communication with your client. They will make sure that that happens. So, but in all other respects, the motion is denied. Thank you.
All right. Thank you, Your Honor.
Thank you.
Court does call the case, People versus Kevin Salisbury.
Custody attorney for the people.
What? He's hiding.
Honor David Chan, on behalf of Kevin Salisbury.
Your name?
Hello, Your Honor, Kevin Salisbury.
Your Honor, we are
I recognize you.
How are you?
How you doing?
Very good.
at a sobriety date now.
What?
11/9/2024 is a sobriety date. So if he doesn't do anything stupid in the next month or so, he's going to have a year of sobriety.
Really?
Gratefully so. Yes, Your Honor.
Oh, my
For the
gosh.
first time in
When
my-
I first met you, I would have never thought in my life that would happen.
Me either.
Well, I won't see you then.
And there's
or
miracles
make
happen. I
you-
mean, you got overwater going over the dark side. So I do know that miracles do happen. I'm just saying, it's just, so there's an example
said
of
it-
another miracle.
You
But
said
we
if he
need-
doesn't do anything stupid, but showing up at a Patriots anything is really stupid.
In all fairness, Your Honor, my
It's okay.
fan.
Just saying.
Yeah.
All right.
So we just have to clean up some stuff, some other stuff, wreckage, and we could just have a month adjournment. I think we're gonna be able to
To get
resolve
that
all.
all cleaned up and
Yes,
probable cause conference, and we'll be adjourned to November 13th, 2025, 9 a.m. Bond will continue.
Thank
If I hadn't to hear that, Mr. Salisbury, I will say this, I'll say it publicly, I'm proud of you.
Thank you, Your Honor. That means a lot to me. Thank you.
You take care of yourself.
Today's proceedings showed just how different every courtroom appearance can be, even when they're all heard by the same judge. We watched a warrant issued after a defendant failed to appear, another defendant remanded into custody after failing to comply with community corrections, and a complex stalking case where the court refused to loosen bond conditions because protecting the alleged victims and preserving the integrity of the judicial process remained the top priority. The judge carefully balanced public safety with each defendant's constitutional rights, applying bond conditions designed to prevent further violations while allowing the legal process to move forward. At the same time, the courtroom also delivered one of the day's most encouraging moments, as Kevin Salisbury was publicly praised for maintaining nearly a year of sobriety, a reminder that genuine rehabilitation is possible when someone consistently follows through with treatment and accountability. Together, these hearings demonstrate that the justice system isn't simply about punishment. It's about enforcing court orders, protecting victims, encouraging rehabilitation, and ensuring every case proceeds according to the law. Which moment stood out to you the most today? Did the judge strike the right balance in each decision? Share your thoughts in the comments below. And if you enjoy real courtroom breakdowns with legal insight and full case analysis, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss another courtroom verdict.
What we saw today was a powerful reminder that courtroom decisions can change in seconds. One defendant lost her bond after failing to comply with community corrections, while another saw his request for relaxed phone restrictions denied because the court remained concerned about repeated alleged violations. But the hearing also showed the other side of justice, when the judge publicly recognized Kevin Salisbury for nearly a year of sobriety and praised his progress. These cases show that accountability, public safety, and rehabilitation can all play a role in the courtroom. But what do you think? Did the judge make the right call in each case?